So as real estate agents, we continually hear about elder law abuse and father goes on. And recently I saw a news story about an attorney who won a large verdict for a woman in Long Beach who was sold out of her home. And I see these things happening as an agent from time to time. And I'm really excited to bring to you an attorney who won the case. Very difficult to do. The litigation is expensive. It's difficult. And yet in this case, ended up, looks like, awarded $4 million in damages. Bill Chapman, thank you so much for making time for us today.
You bet. Glad to be here. Thanks for having me on your show, Bill.
Just so I understand, how did you get into elder law and litigation? Which of those, are you a litigator that did this elder law case? Are you an elder law attorney that litigated, or do you do both regularly?
Well, that's a good question. I've been in practice over 40 years, and I've generally refer to myself as a civil litigator, not criminal. I don't do tax. I used to say I don't do family law and probate, but now I've been pulled into some of those. But my expertise is really civil litigation. My primary focus is business litigation, but I do have a background earlier in my career in personal injury matters, both on the defense and plaintiff side. And when a friend of mine a real estate broker friend of mine contacted me about this case, it just cried out to me for representation, and I thought I was capable of doing that, so I jumped in.
So, and I appreciate, your attorney and it's your client, and certain things are privileged, and I don't know if it's settled or subject to appeal, so I don't want to cross your lines I'm not supposed to, and we apologize in advance. But, I get phone calls from people all the time who say, I've been subjected to fraud, or my mom's been subjected to fraud. And I'm sure you do too. What was it about this particular case that you felt that it was viable, that you could litigate it, and more importantly, litigate successfully?
Yeah, well, the key facts to me when this case came to me was, number one, the client, and by the way, the case has been tried to a jury. We have a jury verdict. It's a public record. The transcript has been prepared. Obviously, there are other things that I won't talk about that are some of my personal thoughts that are not public. But anyway, the key facts that came out to me were, number one, she's 80 years old. She was like 78 at the time, so an elderly person. She was living in a nursing home, and she had suffered a stroke a couple months before this purported transaction, which I call it purported because the judge declared that the grant deed is void and unenforceable, although she did admit she signed it. And she also had severe bed sores. She was essentially bedridden. And so this woman, and she had no real family. She had a sister, but her sister is mentally disabled, and she was actually trying to help her sister, which is part of the case. She ended up finding some long lost relatives, which found my friend, the real estate broker who brought me into the case. But otherwise, this would have gone on and nobody would have ever known, I'm afraid.
So a couple of things that you say. One is that she was in the nursing home when the deed was executed, the deed that was determined to be invalid at some point.
Yeah.
So that's a clue right there, right?
Yes.
Number one. What else was it that at least got your interest, or the court found made it that it was not valid? Meaning, did the signature appear to be different than the one she had previously? Was it physically noticeable? Was it any other facts that as a realtor I should look at that and say, well, that doesn't look right, it doesn't sound right in a situation?
Yeah, and I any competent realtor, I think, could have easily prevented this from happening. And that's one of the things that jumped out at me, is that I didn't mention is the defendant is a real estate. He's not a real estate broker, but he's a real estate investor. And my friend who referred the case to me did a little homework and said this man actually invested in, at the time, he thought 28 properties in Southern California, rental, single family, multifamily rentals. And so that tells you that this guy was not just bumbling around and forgot to do things correctly. So that's another big fact, is his expertise. He was not a layperson. He was a sophisticated real estate investor. At the time, we estimated that his investments were in the neighborhood of the gross value about 20-30 million. Turns out, yeah, there were more like 40 million. Some other properties we found. But his sophistication was another important factor. Also, the other facts that really jumped out at me, Bill, and told me this was a case was that when I heard about this and found out there was a grant deed, my client signed it, was recorded, and this gentleman, the defendant, Ken Lamphere, was on title. And so I started to ask for all the documents like we always do. And there was no purchase sale agreement. There was no, although the defendants claimed that he agreed to pay $300,000 for this property, which is actually worth $800,000, and he has some excuses and reasons for that. That there was no promissory note for the $300,000 promise to pay. Did not pay cash. In fact, he never paid any. Another big fact that jumped out at me is he never paid a dime. He verbally promised no written promissory note, no purchase sale agreement, no trust deed, no escrow. Those are all red flags going up all over the place that told me this is a fraud and needs to be prosecuted.
Now, in this case, I don't remember, I think I looked it up. He hadn't resold the property. It was still titled in his name at the time of this court case being resolved. So I think had he tried to sell the property, he would have had a problem, and that a title company would say, this is an uninsured deed, and we want to go back and verify and the circumstances of her signing it. And my guess is that, did he keep it for a while? Was he renting the property, or what was he doing with the property?
Well, it's hard to tell. There's a lot of speculation about his motives, because obviously he claims his motives were altruistic. He said it was all trying to help this elderly woman out. But some of the facts that were kind of interesting is these other properties, he was not a flipper. Other properties that he held, he bought, he was just building an empire. In fact, another fact that came out that kind of interests me is this man is not only a sophisticated real estate investor, but it turns out he's a retired aerospace engineer, not just a retired aerospace engineer, but he worked on the stealth bomber. In his deposition, I asked him to tell me his greatest achievements in his career. He said, well, I graduated #1 in my class at Long Beach State in the math department. I went on as an aerospace engineer, worked on the stealth bomber. I was responsible for, he testified, developing the mathematical and physical calculations to prevent the stealth bomber from being detected by radar. This guy is a really smart guy. And to have 28 properties where he's renting them out, and he has on any of those properties, that he acquired, purchase sale agreement. If there was, it was bought on credit, if there's a loan, there'd be a promissory note, trust deed, and all of that. But the point is that he may have been, and I don't know the psychology of this guy, but he may have been just trying to build his empire, leave it to his estate or whatever. Whether he thought about a title company challenging it or whatever, I don't know. That never really came out. But again, one thing I should add here is the elder abuse statute is very specific, and it doesn't really require an intent, a fraudulent intent. Although we did have we had 2 fraud causes of action, and the jury found that he had fraudulent intent. But the actual elder abuse claim is based on a statute. And if you prove that someone is 65 years or older, and that I'm summarizing a very complicated statute, but just for your listeners, if the person is 65 years or older and the transaction and the defendant knew or should have known that the transaction would be harmful to the elder, that is elder abuse.
Wow.
And the remedies are rather draconian. There can be a doubling of the property that was taken. In our case, we also proved that it was done with fraud, malice, or oppression, allowed us to get punitive damages, which is up to 10% of the individual's net worth. And so we got an award of $3 million in punitive damages.
Wow. Now, you mentioned your client was in the facility. Was she competent for herself, or did you have to create a conservatorship, or how did you manage?
Yeah. What we did is, in litigation, we had a cousin who's the individual she ultimately found, or her sister, who was mentally disabled, got out and found this long lost cousin. And the cousin and his wife were very involved in trying to help her out, and they were competent. They were fairly sophisticated. So we had the cousin appointed as what's called a guardian ad litem, which means a guardian solely for the purpose of this litigation. They also, the wife of the cousin, got a power of attorney through another attorney, estate planning attorney. I didn't do that, but she had power of attorney to do certain things, but limited for this litigation. We had the cousin that was really my main contact.
So, and I don't know if you're able to discuss this in detail in this case in particular, but one of the things I find when people come to me and say, well, my aunt, mother, whatever was ripped off, and here's the case, and you look at the facts and it appears to be, me as a realtor, I look at it, looks to me like something was done wrong. The next step is getting an attorney. The challenge is, well, who's paying for it, right? Because you're talking about, in this case, perhaps millions of dollars in terms of potential damages, but you're talking about, I would think, hundreds of thousands of dollars to get to a jury verdict. And even that doesn't guarantee payment. There's appeals. I have a client who, the attorney who referred me the case is the appellate attorney, because this client sued and won and had to appeal and win again. And I think they spent about $500,000. They happen to have those resources. What do people do who don't have those resources?
Well, that's a good question. And your estimates are actually pretty right on. I'm surprised. A lot of people think, oh, you just go into court, try a case and win. It doesn't cost that much. But yeah, we're going to be filing a motion for attorney's fees. And I can't give an exact number, but it's in the ballpark you're talking about. And to answer your question about who paid for this, well, this cousin, his wife, they had sufficient assets, and they paid hourly in the beginning and paid a substantial amount of money, and actually moved some of their investments around to pay for it, because they really believed in this case and wanted to help their cousin. We got to a point where we actually switched to what's called a hybrid, where we lowered our hourly rate and took a partial contingency. And then they said, we're really running out of money. We want this to go forward, but they were just suffering under the financial pressure. And we said at that point, before the trial started, we said, we as a firm, our firm normally doesn't do pure contingency fee cases, but we said, we now know enough about this case. We have the evidence. We're willing to take the risk of going to trial, to appeal, or whatever. So we switch it to a full contingent fee, to where the cousin doesn't have to worry about paying anymore, and we're just kind of financing it on our own because we believe in the case.
I would think, having been around those a few times, that requires a client who is cooperative, who is respectful. It's almost like they're auditioning for that opportunity, because it's just too easy to say no if the client's difficult. And it must be difficult as a businessman to say yes, because you're talking about a lot of money, and there's no guarantees in life. When you have a jury in particular, there's no guarantee at all. That's your case. And again, I don't mean to get anything as confidential. In general, though, it seems to me there's no alternative unless they have a substantial amount of money up front. Like I've not met an attorney who would take a case like that purely on contingency.
Yeah, you're right. The contingency fee lawyers are typically going to be in the personal injury space, where they have clear liability, significant damages, and an insurance company where they know they can collect.
Right.
And they're more cookie cutter. I don't want to say it that way, but just a little more predictable.
Right.
Whereas, and they also, as a firm, over the years, they've hit enough of those big cases that they have, their own bankroll. There are some firms out there that will finance litigation. It's tough to get, and they take a big piece of that. But you're right. You made a really good point, and that is, we as a firm, and I particularly over the years, have noticed that the outcome of these cases, especially a jury trial, can be heavily influenced by the credibility of my client, the plaintiff in this case. And when I've had good clients, I have gotten really, really good results at trial. Juries want to help good people, and the judge will instruct them on the finer points of the law. And the juries, my experience is, they try very hard to listen to the judge, apply the law, but they also are influenced by, as human beings, wanting to do what's right, what their gut tells them. Right. They want to help the good guy. and they kind of this individual defendant actually was one of the best, if you can say it that way, liars or best crooks or best defendants I've ever seen. He walks in the room when we took his deposition, and he walks around, wants to shake everybody's hand. How you doing? And he's just a nice guy on the surface. His problem was what he did not support his personality, his charisma, and that's what we focused on at trial. It was a tough job, but we were able to cross-examine him, prove he was, a bad guy. The jury obviously sided with us, and like our client was testifying video remote testimony to the court while in the nursing home. She couldn't come physically, and so we had a video a remote testimony of her lying in her hospital bed, could only move her right arm, paralyzed on the left side, and very compelling, nice lady, very sympathetic. We don't overplay that. We just let the jury see it, and they pick up on it on their own.
My late father was an attorney, and one thing I learned is there's almost always two sides of the story, and you meet the guy who's friendly and outgoing and big smile. I was in court once on a sheriff's sale where property was being sold, where the defendant lost and the plaintiff had the right to sell the property. And this defendant shows up, he's sympathetic, he's in a wheelchair and he's elderly and seems like a really nice man. Turns out the case was he had beaten the plaintiff with a hammer, and the plaintiff had lived as a vegetable for 20 years. And the family had to support this person, and he avoided the foreclosure for like 20 years or something. And finally, so it's like, wow, he's a nice, sympathetic guy. Not really. He beat the plaintiff literally with a hammer. Like, he's not a nice guy. So you never really know.
Well, yeah, this guy, the defendant, Ken Lamfera, came into court and testified that he basically said he's Mother Teresa. He said he gives to the charity, to his church. He helps people out. He trusts people. That's why he didn't have any documents, because he has workers. He said, he just pays them whatever they say, and he tries to help people out. And he was a real schmoozer, but in the end, the deeds disproved his claims, and he went down, in a bad way.
So just, to kind of wrap up a little bit, this must have been very exciting to take to trial, to win, and the publicity. I saw it on, I think the Bar Association News or something, and I know you got other publicity as well. It must be very exciting. What's it like to get back to work and do the normal humdrum legal business that you do most of your career? What's that like?
Yeah, one of my colleagues said, Bill, because he and I do a lot of business litigation. It's more mundane. We're advocates for all of our clients. We try to, get into their cases and advocate. But this one, his comment, I think, kind of summed it up. He said, Bill, this case is why you and I went to law school. And that's about it. When you're young and idealistic, you don't go to law school and say, I'm going to just go in there and represent a bunch of corporations and business people and fight about money, contracts and stuff like that. Although that's what happens in the real world. But you go to law school watching some, movie or something where there's a hero and there's, and you just really feel like there's a cause that's being fought for. And in this case, it was there. And so it was very rewarding. Going back to your question, I have an oral argument tomorrow in the Court of Appeal in another case. And I won't say it's mundane. It's actually very, it's got some very interesting facts, but it does not have the same kind of a personal appeal that this case had.
Well, you are the hero. Like I said, I looked into the case a little bit myself before I reached out to you, and I see these things happen. Rarely do people have the client you had who has the fortitude and the commitment financially, and they're fortunate to find an attorney like you who's able to work out the business side of this, which it sounds kind of ugly. Shouldn't justice happen without business? And the answer is, it needs somebody like you to do that. For those who want to reach out to a real life hero and attorney and talk about perhaps a case they have that might be appropriate elder law, primarily civil litigation related things, your website is mbkchapman.com. I'll put that in the description down below. Is that the best way to reach out to you? Yeah, you bet. And our website will also have our phone number that is 949-767-3910. They can reach out to us that way. And your business attorney is both in California and Florida. That's an interesting. That's what the website says. What's the combination? The only place I've lived in my life is California and Florida. So I'm curious, what's the connection?
Well, we opened an office in Florida early on after we started the firm, and we have a couple of attorneys out there. I actually, a lot of my clients are surprised to hear that I predominantly practice in California, but I've handled cases in New York, Texas, Iowa, Illinois, Washington, a number of states, and that in litigation, I'm allowed to get admitted for a particular case, even though I'm not licensed in that jurisdiction. And then I get local counsel who knows the local rules and procedures.
Very nice. Well, Bill Chapman, again, mbkchapman.com. I'll have the notes below along with a phone number. You are a hero. Thank you for the work you did in her case. Hopefully, thank you for elevating the practice of real estate, both getting rid of the bad guys and inspiring good guys to be more careful. I really appreciate your time today.
Well, thanks for having me. I've enjoyed it. And thank you for bringing this to other people's attention.
Oh, my pleasure. Thank you so much.
Okay.